In this video, we will continue our look at issues concerning the performance of a contract for the sale of goods. Specifically, what happens when a contract is made and one party begins to doubt the other party's ability or willingness to perform its obligations under that contract. The issues of insecurity and repudiation. The situation here implicates two sets of closely related legal rights: the right to demand adequate assurances of performance, and the rights arising upon an anticipatory repudiation of a contract. Two concepts that should be familiar to you from your study of the common law of contracts. Let's start with the first principle first: the right to demand adequate assurances. After a contract is made, lots of things might happen that make a party uneasy about the other party's ability or willingness to perform. Like what? Consider these examples. Perhaps, from the seller's perspective, the buyer pays late for a prior installment or is experiencing financial trouble, or the buyer discontinues the line of business that the seller was selling goods to the buyer for. From the buyer's perspective, perhaps the seller delivers a non-conforming prototype of the goods that the seller is ultimately responsible to deliver to the buyer. Or perhaps the seller makes a late delivery of prior installments in an installment contract. Or perhaps the seller faces a shortage of raw materials or inventory for the goods that the seller is supposed to provide to the buyer. Or finally, perhaps the seller's manufacturing facilities are damaged or destroyed, leaving the buyer skeptical that the seller will be able to actually provide the buyer with the goods. Whatever the case may be, when one party to the contract has reason to believe that the other party will be unable or unwilling to perform, stated differently, when one party has reasonable grounds for insecurity, then consistent with the common law of contracts, under Article 2, Section 609, subsection 1, that party may in writing demand adequate assurances of future performance from the other party and suspend its own performance until it receives such assurances from the other party. Moreover, under subsection 4 of 609, the other party's failure to provide adequate assurances in a reasonable time may be treated as a repudiation of the contract. Stated differently, when one party receives a justified demand for adequate assurances and then fails to provide adequate assurances, it's like saying, I'm not going to perform, I'm going to breach. The rationale for this rule is to avoid uncertainty. When one party has reasonable doubts about the other party's capability to perform, she does not have to simply stand by and see what happens. She can ask, what's going on? Give me assurances that you will perform. The problem with the rights created under these provisions, however, is that they replace one type of uncertainty with another. First, a contract party wishing to exercise her rights under 609 has to figure out what qualifies as a reasonable basis for insecurity. In some cases, it will be obvious that there is a reasonable basis for insecurity, but in many cases, the facts will be ambiguous and it's not obvious. What is clear is that if there is a reasonable basis for insecurity, then under 609, the party has the right to demand adequate assurances and to suspend its own performance. But if not, if the party demands adequate assurances when it does not have a reasonable grounds to do so, then the demanding party might itself be in breach. The demanding party will be repudiating the contract by withholding its own performance unless it gets something that it is not entitled to. So what qualifies as a reasonable grounds for insecurity under 609? Article 2 does codify one statutory grounds for insecurity. Under Section 210, remember we looked closely at that section in our discussion of assignment and delegation, subsection 6 says that a delegation of duties under the contract provides reasonable grounds for insecurity for the non-delegating party. The delegation provides reasonable grounds for the non-delegating party to demand adequate assurances from the delegatee, the party to whom the duty to perform was transferred. Aside from that one codified scenario, however, in all other cases, the question of what qualifies as a reasonable grounds for insecurity is a question of fact, and how a court may resolve that question is difficult to predict ex ante. And here the UCC does not provide a lot of guidance. Subsection 2 of 609 says that at least between merchants, the reasonableness of grounds for insecurity is determined according to commercial standards, according to an objective standard based on what other merchants or other parties in business would expect to be a cause for insecurity. But it's hard to know what this provision adds to our understanding, because presumably an objective standard also applies among non-merchants. After all, the statute requires reasonable grounds for insecurity, and reasonable is an objective standard. Even if a party can answer this question correctly, even if she has a reasonable basis for insecurity, the party faces another uncertainty. What kinds of assurances can she demand under 609? What she is statutorily entitled to under 609 is adequate assurances. assurances that are adequate or reasonable given the circumstances. So the party making the demand must decide whether what she is demanding is merely adequate or goes beyond what would be adequate under the circumstances, goes beyond what would be reasonable. If she demands too little, for example, just verbal assurances from the other party that it will indeed perform its obligations under the contract, that kind of assurance may be worthless to rely upon. But if she demands too much, if she demands something unreasonable, something that would be more than adequate, something that is beyond what she is statutorily entitled to, then that demand may be treated as a breach. Then the demanding party might itself be in breach. The demanding party will be repudiating the contract by withholding its own performance unless it gets something that it is not entitled to. So, what kind of assurances are adequate under 609? What kind of assurances can a party demand of the other party without the demand itself breaching the contract? For example, if the seller has reasonable doubts about the buyer's ability to pay for goods that they contracted for, then can the seller demand the buyer to pay in advance for the goods before they are tendered, or otherwise to provide some kind of third party guarantee of the buyer's payment? It's important to note that anything a contract party demands under 609 in terms of an assurance will be more than what she is contractually entitled to expect from the other party, because the nature of the demand is that it is asking the other party for something beyond its existing contractual commitments, something that gives assurance of the performance of those obligations. So simply demanding something beyond what you're contractually entitled to does not make your demand unjustified or unreasonable. At the same time, however, 609 cannot give one party a unilateral right to rewrite the contract. 609 cannot give one party the right to demand something that she is not contractually entitled to and that would materially change the terms of the contract for the other party. Instead, what she must demand is something that is merely adequate or reasonable, something that does not materially change the other party's contractual obligation. Comment 4 to 609 confirms that reasonableness is determined in context, that in some cases, verbal assurance may be reasonable, but in others, something more may be reasonable. Unfortunately, it doesn't provide much more guidance than that. So, what constitutes a reasonable demand is in all cases a question of fact, presenting a second uncertainty, because it may be difficult ex ante to predict how a court might resolve that question ex post facto. If you ask for too much, if you ask for assurances that would be more than adequate, if you make a demand that is unreasonable, then the court might later find that you were in breach. One final uncertainty for the party demanding adequate assurances is whether the other party's response to the demand is adequate. Does the response adequately assure that performance will be forthcoming when it is due? Or is the response inadequate? Or maybe the response is ambiguous, something in between. Accurately resolving this question is again critical, because if the response is inadequate, then under 609, the failure to provide adequate assurances may itself be treated as a repudiation or breach of the contract. But if the response does provide adequate assurances of performance, then the party making the demand can no longer withhold its own performance. It must instead resume its own performance, or otherwise it will be in breach. Again, this is a question of fact, presenting a third uncertainty for the party making the demand because it can be difficult to predict ex ante how a court might resolve that question ex post. Related to the right to request adequate assurances is another concept that should be familiar to you from your study of the common law of contracts, repudiation. Repudiation of a contract is closely related to breach of a contract. Breach occurs when one party fails to perform its obligations under a contract when performance of those obligations was due. By contrast, a repudiation occurs before performance is due, when one party manifests its intent to breach its performance obligation before that performance is due. Stated differently, repudiation is when one party manifests an intent to commit a future breach of the contract. Hence, the term is often referred to as an anticipatory repudiation. A repudiation can be either through words or conduct, anything that manifests the intent of a contract party that she is unwilling or unable to perform. Comment 1 to 610 elaborates on this point. It says that anticipatory repudiation centers upon an overt communication of intention or an action which renders performance impossible or demonstrates a clear determination to not continue with performance. So what is required is words or conduct, any objective manifestation of intent that performance will not be forthcoming when it is contractually due. Under 609, the provision that we just looked at dealing with the right to demand adequate assurances, a repudiation may be treated as creating reasonable grounds for insecurity. Upon a repudiation, the non-repudiating party may exercise its rights under 609 to demand adequate assurances from the repudiating party and hope that the repudiating party changes her mind. But 610 gives the non-repudiating party some additional rights. Specifically, the non-repudiating party may suspend its own performance and choose either to await performance, hoping that the repudiating party will change her mind, or treat the repudiation, that is, treat the manifested intent to commit a future breach as a present breach and immediately seek a remedy for breach. So the rights of the non-repudiating party are clear. What is less clear is what in practice constitutes a repudiation under 610. An easy case would be where one party unequivocally refuses to perform all of her obligations under the contract. A harder case, the kind that you're more likely to see in the real world, is when one party repudiates only certain aspects of her contractual obligation. Under the common law of contracts, you may remember that a repudiation must be of an obligation that, if unperformed, would constitute a material breach, as distinguished from minor breach or substantial performance. Under the UCC, however, the repudiation must be of an obligation that, if unperformed, would substantially impair the value of the contract to the non-repudiating party. Substantial impairment is a recurring concept under Article 2, one that we will see again later in this course. In short, it is Article 2's way of saying material breach. As it applies in the context of repudiation under 610, consistent with the common law of contracts, 610 says that not just any kind of repudiation gives rise to rights for the non-repudiating party. Only a repudiation of important facets of the contract, facets that would substantially impair the value of the contract as a whole, allows the non-repudiating party to treat the repudiation as a present breach. But what constitutes substantial impairment, like what constitutes a material breach as distinguished from minor breach or substantial performance, is not a bright line test. It's one that is difficult to predict ex ante how a court might resolve ex post. Consequently, whether a repudiation by one party gives rise to rights for the other party under 610 presents similar uncertainties to what we just saw under 609 with respect to what constitutes a reasonable grounds for insecurity and the right to demand adequate assurances. Specifically, if the party seeking to exercise its rights under 610 guesses wrong, either misreads the other party's intentions, thinking the other party is manifesting a clear intention to not perform, when in fact the other party may be just waffling or expressing some uncertainty, or thinks that what was repudiated by the other party substantially impairs the value of the contract, but a court finds differently, then the non-repudiating party, by suspending her own performance under the contract, has now committed a breach. Add to these uncertainties that under 611, the repudiating party may later retract her repudiation. Pursuant to 611, a repudiation may be retracted at any time before performance of the repudiated obligation is actually due under the contract. Retraction is permitted unless the non-repudiating party has already either canceled the contract, materially changed her position as a result of the repudiation, or otherwise indicated that it considers the repudiation to be final. So the upshot is, like the right to demand adequate assurances under 609, a party seeking to exercise its rights under 610 must proceed cautiously. And that's a good place to conclude our look at insecurity and repudiation. In this video, we consider the rights one party has when it reasonably doubts the other party's ability or willingness to perform. Those rights include the right to demand adequate assurances of performance under 609 and the rights arising upon an anticipatory repudiation under 610. In the next video, we will conclude our look at issues concerning the performance of a contract for the sale of goods by considering what kinds of post-contracting events may excuse a party from performance under the contract.